Good morning, everyone. Thank you for joining us on this Monday after a holiday. We do appreciate everyone being here. Thank you for coming to our first monthly Disability Rights South Carolina University presentation on guardianship and what to know before you file. I've got just a couple of housekeeping matters. My name is Erin Hare. I direct the outreach efforts for Disability Rights South Carolina. If you tune into more of these, I will probably be a regular fixture, so I will be doing the welcoming. We are working with a company who is facilitating this session, so he's got everyone muted. Just so we can run through this. We're trying to be cognizant of everybody's time. We know we have the lunch hour and that is it. So we are just kind of to maintain some order and let our presenters run through. We're keeping everybody muted. We will have some time for questions at the end. We will be taking those in the chat. I will read those off. If you're unable to use the chat or don't feel comfortable, please do utilize the raised hand option at the bottom of your screen, and then we will have Phil unmute you and you can ask your question. One caveat about the questions: if you have a question that's very personal and pertains to your particular situation, that is going to be a question that we will probably want you to give us a call for. If you have clarifying questions, questions about the presentation, kind of general questions about next steps or things like that, we would be glad to take those questions. Just know that if you ask a question that has to do with your personal details, we're probably going to refer you, and our contact information will be up at the end of the presentation. So let's get this kicked off. We have a hard stop at 1 p.m. So I'm going to introduce our speakers and we will let them take it away. First, we have Sarah St. Onge, who is an attorney with Melinda Elder Law, and she has over 15 years experience in advocating for people with disabilities and their families. She has experience in the fields of estate planning, probate, elder law, administrative law, mental health law, appellate practice, and affirmative litigation. We also have Anna Maria Connor from Disability Rights South Carolina. She is a longtime attorney and team leader, and she works on abuse and neglect and community integration issues statewide. So I'm going to let those ladies take it away. Thank you so much for being here.
Next slide. Okay, first of all, this is
yes, so we have a calendar. We will have one of these monthly, and please refer to our website about the next sessions. Our next one is February 15th, and you'll be hearing me talking about accessible voting. Okay, now take it away.
Okay, next slide. First of all, we'll do a little bit about DRSC. For those of you who don't know us, we're a private nonprofit providing free services. We're mandated by state and federal law to protect the rights of people with disabilities in South Carolina. And a lot of what we do is look at agencies and entities that provide services or treatment to people with disabilities to make sure they're doing a good job. Our mission is always to protect and advance the legal, civil, and human rights of people with disabilities in South Carolina. And you may know us by our former name, Protection and Advocacy for People with Disabilities. So take comfort in the fact that the only thing that has changed, other than a few faces, is the name of the organization. We are now Disability Rights South Carolina. Next slide, please. So today we're looking at, as we talked about, providing services, free information and referral. If we don't work on your problem, we try to get you to somebody who can. Legal support, which can provide technical assistance, legal advice. Sometimes we open up a case, which may or may not mean going into court or filing a complaint with an agency. Education about your rights and about the law. Education about where you can get services, and of course outreach, which can include sessions like today. It could also include more targeted sessions. And again, we always try to teach people about what we do and who we are. Monitoring of facilities and services and investigations. So we make on-site visit. We also do some investigations of abuse, neglect, and exploitation, and public policy work. Next slide. Sarah, I'm going to ask you to take it away from this point on.
I think maybe we have some housekeeping issues at first. I noticed somebody had their hand up. Phil, can you help us with that and see if there's a problem?
That was a mistake. So no problem.
Yeah. All right, next slide, please. Oh, no, go back one slide, sorry. My name is Sarah St. Ange. I'm an attorney here at a private law firm, and we handle guardianships and conservatorships in South Carolina. And one of the things, let me make sure, yeah, okay. I just kind of thought it might help everybody to kind of know what the process is when you call an attorney. So you call an attorney and you say, you know, I need to get guardianship. What happens next? And a lot of people may have questions about that. And here, the first thing that happens, and this happens the same thing if you're calling disability rights, is we have an intake or a screening process. And when it comes to guardianship, those intakes can go they can be very different. Like somebody may call and they may be concerned about their mom and their mom's boyfriend and her spending, but it could be that the issue is just that, you know, mom still plays bridge and she pays all her own bills and she does everything for herself. That's not an appropriate situation for guardianship. Maybe she needs some estate planning or other services we might offer. But if she's competent, then she doesn't need guardianship. And so our intake people, our receptionists, kind of work through those issues. But let's say it's much more serious. Let's say that mom is in a nursing home and she has end-stage Alzheimer's, yet money is disappearing from her account. That is a very urgent situation where we need to get them in. Guardianship may not be what is needed, but it may be part of the process. If somebody is taking somebody else's money and they're going to need to apply for Medicaid, that could be a really big issue. And so we really need to get them in and see if guardianship is something that they need. So the second step in the process is we send out a questionnaire and ask lots of questions. And then after they send back the questionnaire, we have a consultation. And if we do need to move forward with guardianship, then we will send them an engagement agreement and they'll have to sign that agreement and get back to us. And so that's basically the process for how this all gets started here. Next slide. So I thought maybe a way to start thinking about this is the questions. What questions need to be asked by somebody who's considering, do they need to be guardian over another person? So, you know, we need to know who is it that needs support. We need to know what support is needed. And maybe they don't need guardianship. Maybe they need services through a department of the state. We also need to know who else is involved. Is there a rep payee being paid, you know, receiving Social Security benefits? Do they have an agent? Anna Maria is going to get into powers of attorney and some of those alternatives, but we need to know who is caring for that person. We also need to know who else is going to be involved, who's going to apply to be guardianship if we're going in that direction, who is going to be the person who's going to need a guardian. Does there have to be a co-respondent? And in South Carolina, under current law, there always has to be somebody else, not just a petitioner and the person who maybe needs a guardian, but there has to be a co-respondent. So we need to know all those players. Next slide. We also need to ask what is the problem that needs solving? This is huge. This is the major question. What is going on? Because guardianship may be a solution to that problem, but it may not be a solution to the problem. So we need to know what's going on. In the example, money is disappearing from somebody's checking account. Well, who has access to that checking account? How can we stop that access? What do we need to do? So that's the problem. The problem is money's disappearing. It's not necessarily that the problem is this person doesn't have somebody who can make decisions for them. Sometimes that's the problem, but it is it's that you know who needs what problem needs to be solving. So that's really what we got to look at. Also, we really need to know under the current law, they want to know, have you tried anything else? What else has been tried to resolve that problem? Have you talked to the person? You know, what solutions have you tried to solve the problem? Another thing is there a less restrictive way to solve the problem? You know, is it somebody just needs an agent to manage their money at this point and they need to name somebody to manage their money, but they're competent? Then that would be a less restrictive way to solve the problem. You also, and I think Anna Maria will get into this a little bit, but you need to know what impact there will be on this determination of incapacity. How is the person's life going to be changed if they have a guardian? There may be some negative effects to that. There may be some positive effects to that. You really need to be always thinking, you know, what will happen? What will happen if we make this change? And there are some definite negative consequences that lots of times people haven't thought about when they come to talk to us about guardianship. Next slide. So we want to know when we're talking to people if there is a less restrictive or another way about guardianship. And the reason why we need to know that is because the law says that guardianship has to be a last resort, that guardianship should only be applied when somebody is incapacitated and when there's no other way to meet their needs except through guardianship. And there's a definition, probably when we come back in November and talk about these issues again, there's a very complicated definition of what incapacitated means. So for example, I may have a disability that prevents me from communicating to most people, but some people may understand me just fine. And so those people could offer me supports and help me communicate. That would be an example of supported decision-making. We also have powers of attorney. I have a power of attorney. Everybody should have a power of attorney. So if I become incapacitated, I've already decided who I want to manage my affairs. Usually, if you have a power of attorney, you're not going to need a guardian. So that's another thing that we need to look at. Has the person already decided who they want to manage their affairs for them? There's also a statute called the Adult Healthcare Consent Act and the Adult Students with Disabilities Educational Rights Consent Act. And I think Anna Maria is going to talk about the Adult Health Consent Act, but I can't remember if she had the educational rights. But as many of you probably know, when somebody turns 18, they get to decide as to their educational rights, even if they're a student who's receiving special education services. And we have a statute in South Carolina that allows that individual to name an agent who can manage them. Manage their thing. It allows the student to pick somebody to support them in their decisions. And it also provides that if the student cannot communicate, that essentially their next of kin makes education decisions. So if the problem is that, well, when my son or daughter turns age 18, they're not going to have anybody to sign their individual education program. Well, there's an alternative to that. We may not need guardianship just for that purpose because there's an alternative. There's the REP Payee program through Social Security. And also there's always additional services and alternative interventions. Next slide. So another question, when? We have a lot of very nervous parents of 17-year-olds call our office. And they want to go ahead and get guardianship prior to turning 18. And honestly, in my opinion, my legal opinion is that there's no jurisdiction for that. We have to wait until the individual is age 18. But again, we have the Educational Rights Consent Act. We have the Adult Healthcare Consent Act. There is the REP Payee program from Social Security. probably the sky is not going to fall the day the individual turns 18. And so we kind of work through that with the parents, and we help them and make a determination if there's guardianship is needed or we need to proceed. But it really is, guardians do not, you cannot become the guardian of somebody who's under age 18. You have to wait until they're age 18 to be served process. You also really, a really important question is, does this person need to apply for Medicaid? We have found that a lot of times, a lot of our cases involving guardianship or conservatorship really come down to somebody needing Medicaid, and how are we going to get, who's going to sign the application, the Medicaid application? For example, if somebody they may own their house, that doesn't keep them from qualifying for Medicaid. If they need long-term care Medicaid, like nursing home Medicaid or home and community-based services Medicaid, their house is not going to interfere with that. But if they have another piece of property, they may need that piece of property to be solely in their spouse's name, but we may not have the means to get a deed signed if the person is incapacitated. So we may need some kind of, we may need some court intervention in order to have somebody sign the Medicaid application, but also be able to change the allocation of assets that are in their name so that they do go ahead and qualify for Medicaid. So that's another big area we need to ask, when do they need to qualify for Medicaid? And that frequently comes into play when we are dealing with guardianship. Also, they may have, we may need to move forward with guardianship when an individual is getting a settlement, like a personal injury settlement. When they are working with an attorney, they may be able to move forward with that personal injury action. But when the case settles, if they're not competent to be able to agree to the settlement, then there's a very complicated process that has to happen. The circuit court has to approve the settlement, and then the probate court also has to authorize what happens to those funds. So frequently, if the person has a disability, we would be talking about the creation and the funding of a special needs trust. And if the individual is not competent to understand that, we would have to go to court and do a protective proceeding that would have the court authorize the creation and the funding of a special needs trust. And so Medicaid's a little bit beyond that, but there are many reasons we do that instead of a straight conservatorship. But one of the primary ones is so the individual will continue to qualify for Medicaid and possibly SSI as well, which of course is a Social Security program. Perhaps the individual is getting an inheritance and they're not able to manage that property. That's another time when we may have to move forward. Or they own, right now we have one where the individual owns an interest and they inherited a long time ago an interest in the home. And now the home really needs to be sold and we need to put those funds in, again, in a special needs trust. And there's nobody who can sign a deed. And so we're having to do a protective proceeding. And guardianship is a type of protective proceeding, but there are other types. And we have to do that. And that's another time when we need to move forward and advance and go to court. Another example of when we may actually proceed with guardianship is if there's a disagreement among caregivers. Maybe one caregiver thinks that the individual should be in a nursing home, and the other caregiver believes that the individual should continue to live in the community. And so we could maybe have to bring guardianship to resolve that controversy if the individual cannot speak up and assert their own rights. Another time that we may have to bring a protective proceeding is if an individual is being exploited through financial power of attorney. Like I said, I have a power of attorney. I think everybody needs a power of attorney with one exception. If you do not have or cannot afford a bank or somebody, and you do not have anyone in your life who is trustworthy, you're better off actually having a conservator who is under court supervision managing your money than a power of attorney. So there are circumstances where we do proceed with guardianship. Probably one of the most complicated cases that we bring are where an individual has specific vulnerabilities that can't be mitigated in another way. Maybe they have a processing issue where they just are not learning from the past, or they have some difficulty in their lives. They may be able to manage many things very well, but there may be something that's caused by a disability that is making it really hard for them to learn from mistakes. Because I'm a big believer that we learn from mistakes, but if you have a memory issue, you may not be able to learn from your mistakes. So occasionally there are times when we need to proceed with guardianship to protect people from those kinds of vulnerabilities where they just cannot protect themselves. And that is, in that situation, you do not need a guardianship that manages everything. It should be very narrow and very limited. Next slide. So in South Carolina, full guardianship is kind of not necessarily a concept in our law right now. Like in our law, you have to specify what rights are removed. And if you don't specify that a right is removed in the order, it's not removed. So I think in current law, it is a concept that all guardianships really are limited guardianships. Now there's a list of rights that can be removed, and sadly, most of the time, just about everything's checked off on that list. I have noticed a real trend where voting, not just with our firm, but with other firms too, that people are really trying to not check voting unless there's a specific reason to. So most people, even after guardianship, they don't have a full guardianship because they may at least have the right to vote or the right to continue in whatever religious activity they have. So those are some of the things that the rights are typically retained, even when an individual may never be able to exercise those rights. Those rights are certainly not a danger that they have maintained them. And those kinds of rights can't be transferred to a guardian to be exercised. So the individual under guardianship will probably, even in a very restricted guardianship, will probably maintain some rights. So that's one of the things that you need to ask when you're asking, to what extent, is limited guardianship going to work? Also, another question is to say, hey, does this need to be permanent? I was given the example of where we needed a protective proceeding, like to create and fund a special needs trust because somebody received a settlement. Well, they don't need ongoing court intervention in their life forever. It's just a temporary, we can just resolve that in a temporary fashion, get an order from a court, and then the trustee basically takes over from there as a fiduciary. And we don't have the need for any kind of ongoing restrictions over the person's life. And so temporary is one of the things, that's an example. And that's also another way to word that, is to say it's just a protective order and it is not the appointment of a permanent guardian. When you look at the forms that are available online to seek guardianship, the forms specify, you can say what exactly it is that you're asking for. Are you asking for the appointment of a guardian? Are you asking for the person to be found incapacitated? Are you asking for the appointment of just a protective order? So those are the things that are in the forms that we can do, so that, we only want, under the current law, guardianship to the extent, or conservatorship to the extent is necessary. And those are some alternatives. Next slide. Most of these I think are really going to be covered by Anna Maria. So I think that may be my last slide. Next slide. These are some great resources for you. And I think that this is going to be up on YouTube at some point. And so you may be able to come back to those if you can't do a screenshot or write them down. Next. Okay, I think it's up to you, Anna Maria.
Okay, thanks, Sarah. You know, one of the things that we like to remind people of is guardianship is an important matter. It's important for you. It's important for the person that you're trying to protect. And one of the things we always like to remind people of is that guardianship and other forms of decision-making on behalf of other people really affect some very basic and important rights for all of us. The right to vote and serve on juries, the right to decide where you want to live, the right to make healthcare decisions, and the right to make a will. Those are just a few things that are impacted by guardianship. Next slide. So again, we're looking at all the different options that you or somebody in your life may want to know about if they are in the process of deciding, does my family member or does my friend need help? There are lots of options out there. They're very confusing. So what do they all mean? Next slide. First of all, we're always talking about a surrogate decision-making. This is somebody that steps in the shoes of the person who needs help. So this is a surrogate who's going to make decisions concerning the individual and communicate those decisions. It could be a request for help. It could be a decision to sell a property or something like that, or deciding where somebody wants to live. But that decision is made and then it is communicated to a provider. So that's the essence of how this works. Next slide. And what we're asking people to do is think about what all of us do on a normal basis. We all look for information in order to make decisions. We quite often look for what we call supporters. It could be friends, it could be family, colleagues, but that individual is searching for input, both information as well as possibly counsel or advice, and then making a decision and then communicating the decision to the provider. So supported decision-making is just a way to describe somebody who goes out on a normal basis. It could be me, and ask their friends, their family member, their supporters for advice on what I should do. And then once I make that decision, I communicate that decision to a provider. Next slide. So forms of supported decision-making or surrogate decision-making is, first of all, the most restrictive, the guardianship. So you're taking control over the legal affairs, basically the life of the person that you're protecting, and conservatorship, which applies to financial matters. Now, sometimes you have actually one order that appoints a guardian. Quite often they are in charge of the financial affairs, but there are, again, as Sarah talked about, separate orders that can be just conservatorships. And you can at times have somebody who's in charge of the money and somebody else has the guardianship. But we've also talked today about powers of attorney, trust accounts, representative payees, and the Adult Healthcare Consent Act, as well as the Student Act. All of these are different forms of decision-making authority. The guardianship, again, is the most restrictive. If you get a full guardianship, that takes away the person's right to decide where they want to live, if they vote or don't vote, usually everything about their health care and handling money and everything else. Power of attorney is a form where the person can actually give somebody the power to make a decision on their behalf. So that is one of the most useful documents. It's been around for a long time, and everybody, as Sarah said, should have a power of attorney. The great thing about the power of attorney is, again, the right to make the decision stays with the person who has the authority. So the power of attorney for me, it's still my power to make a decision. But if for whatever reason I want to have Sarah as my power of attorney, if something happens and I'm unable to make a decision, then that document would give Sarah the authority to make the decision on my behalf. Again, I retain the power unless I become incapacitated. Let's say I have an accident or I become very ill, and then Sarah, as my POA, can step in and make a decision on my behalf. If for some reason I decide that I no longer want Sarah to make my decision, I can cancel that power of attorney and go without one, which is not advisable, or I can bring in somebody else. So maybe I ask Aaron to be my power of attorney. So then I just come in and I write a new document appointing Aaron. And once I have signed that, she's my new POA. Trust accounts, as Sarah mentioned, special needs trusts and other types of trusts are set up to protect the financial assets of an individual. And they're usually, again, making sure that the person is going to have this account for a long time, but also sometimes protecting their benefits under Medicaid and other areas there. A representative payee is in the Social Security system, and that is somebody who deals with controlling the money that the person receives, the cash benefits the person receives from the Social Security Administration. The Adult Health Care Consent Act is actually a state law, and it really fills in the blanks for people who don't have a guardianship or a power of attorney, or even sometimes if the power of attorney is, let's say that person is out of state, or that person, the person who was given the power of attorney is themselves incapacitated. Let's say a family was in an accident and it was a husband and wife and maybe a sibling of one of them, and that sibling had power of attorney for the family. So all of the decision makers are incapacitated. The Adult Health Care Consent Act actually then looks at the next person in line to make the decision on behalf of the person who needs protecting. So let's say the husband in this instance needs emergency medical treatment. His wife is unconscious at this point in time. His power of attorney is unconscious. The Adult Health Care Consent Act then says, we'll look at the next person, and there's a priority list. So they will look at usually the next closest family member. It could be parents, it could be the husband's sibling, or somebody else in the line of priority, and it goes down all the way through to state agencies and other entities that may need to step in and make decisions to benefit the person who is incapacitated. So again, the Adult Health Care Consent Act is always there. It always provides protections. And it is something that can fill in the blanks if you do not have a power of attorney, or if for some reason your power of attorney is not working, or if something else is going on. Next slide. Okay, so guardianships, the basics. One of the things, again, we always talk about is that it takes a long time. It can be very expensive to get a guardianship. You have to report to the court on an annual basis, especially with the conservatorship, as Sarah talked about. Those are really monitored because of the money, but guardianships are also monitored because, again, the court has a duty to make sure that the guardianship is protecting the person and that they're fulfilling their duties. Now, what happens if the guardian themselves become incapacitated? Sometimes that's planned out and there is somebody who is appointed to step in. The guardian can also add something in there, but you may actually have to go back to court if that is not planned out in advance. Sometimes you actually have a guardian who's not doing a good job, or for some reason, let's say the guardianship was instituted long ago when the person turned 18 because we didn't have the education consent form at that point. So the guardianship was instituted to look at educational matters, but now the individual who's being protected is not incapacitated, they're fully capable, and they want to go back in, then they can go ask the court to remove the guardianship. And that can be done on that basis. It can also be done if the guardian is abusive. But you're looking at, again, having to go back into court to remove that guardianship. You can't just ignore a guardianship order if it has been legally implemented. If the court has issued a guardianship order, it cannot be ignored. Again, you want to look at the basis of the guardianship and also the powers. In South Carolina, as Sarah said, our law really encourages you to try something else first and to be the least restrictive possible, even in your guardianship orders. So it's going to ask you as part of this process that you look at everything the person can do on their own and what they may need help with, and try to write an order that only gives help when it is needed. So that's why we talk about limited or full. The full guardianship is really about the only one that the court recognizes in South Carolina, but they can, again, carve out in their orders the areas where the person can make their own decisions. That maybe you want somebody else to handle the money and some of the other important decisions, but the person still can vote and needs to have the right to vote, or can decide educational matters and needs to have that done. So again, carve out what the person can handle on their own. The other thing to think about with guardianship is that there are very significant legal consequences, and it may create more problems than it solves. Once you become guardian of someone, that's it. You step into the shoes of the parent. And unless that order is rescinded or there's a new guardian appointed or something like that, you are responsible for that person forevermore. And that means legally responsible. So you're going to be the one that gets the calls. You're going to be the one that has to make sure that person has a good home, that has full services. So you are deeply involved in every decision affecting that person for the rest of the tenure of the guardianship. And again, what we're asking as the protection and advocacy group is to think about less restrictive options. Our law does require that you try those first and that you rule those out. And I think that if you go through and you look at the less restrictive options first, again, there are a lot of different ways that you can have supported decision making, and then you can have guardianship as an alternative in the future. So going through the less restrictive options first does not rule out that someday you might have to become full guardianship over someone. Quite often you can come up with a plan. Let's say the person has needs right now, they might need support in making decisions. So what you'll find in one of the links that we provided was a supported decision-making project manual and website. And that talks about coming up with identifying who can help someone make decisions. For instance, in my situation, I have 3 siblings and I have colleagues and I have friends. And so there are different people that I go to sometimes to talk about different topics. I may talk to one of my sisters before I talk to my brother about something, or vice versa. So those would be people who are in my, what we used to call circle of support. And if I were drawing up a supported decision-making agreement or a plan, I might have all 3 of my siblings' names listed as people who are in my circle of support, who I will go to talk about major life decisions, or I may designate that I will talk to my 2 sisters about personal information. I may talk to my brother about buying a new car. I go to him for IT advice, for instance. So I may put him as my supported decision maker in terms of IT and buying cars. But I don't want to talk to my sisters about those things, so they're not in that agreement. Again, I will also then have a supported decision-making agreement. I might have a power of attorney, and then I may have something that in a full estate plan. I might have a medical power of attorney separately. I'm going to have advanced directives, which can say what I want done if I become so ill that a decision has to be made about life supporting measures and things like that. So you can go with, one document. You can have one power of attorney. You can have more than one. You can also have a different layer. So again, you can have power of attorneys that point out one person to make the decision. If that person becomes incapacitated, then the secondary person would step in. And you can also have, again, layers of documents. You can have a supported decision-making agreement, a power of attorney, and a medical power of attorney and advanced directives on top of that. And eventually, again, if you have somebody with a progressive disease or illness, which will make them incapacitated in the future, then you can plan for that and you can agree upon who will be the guardian and what is the triggering event and what needs to happen once you're at that point. Next slide. Okay, we've talked a little bit about the consequences of guardianship. The loss of autonomy and self-determination is associated with higher incidence of abuse, neglect, and exploitation. The more independent people are, the more they are able to report abuse and neglect and to protect themselves from it. That has been proven by a lot of different studies. People under guardianship are less likely to be employed. The process is expensive, attorneys, hearings, evaluations. It's very difficult to modify or terminate a guardianship. So if you do think that you need a guardianship, then take the time to go through a lot of the questions that Sarah talked about. Make sure that you talk to your attorney about a lot of different options and come up with the best order that you can, because you don't want to have to go back in and modify or terminate it. It can be tremendous and continuous responsibility on the guardian, so be prepared for that. What happens if something happens to the guardian? Again, make sure that there are backups to the backup. Damage to the relationship between the guardian and the ward. We see this quite often in situations where parents have gone in, and sometimes even we believe that at a certain point in time the guardianship was necessary, but as you know, it can, because it is a restriction on the right of the individual, it can be offensive to that person. And sometimes they don't mind that the guardianship is there, but they disagree with what the guardian wants them to do at a certain point, and that causes a fight. That cannot always be avoided, but you can actually create a worsening of a relationship once a guardianship is instituted. And one of the other key things to think about in the guardianship arena is the fact that sometimes the guardianship can make a decision for the person they are protecting, what we used to call the ward, but you can't actually force the person to make good choices. So, let's say it's a treatment matter. They refuse to take a certain type of medication. Even though the guardianship is given permission for that medication to be administered, if the person refuses to swallow the pill, what are you going to do at that point? Again, you can lead a horse to water. You cannot always make that person drink the water. Next slide. Okay, we kind of talked about this already. Full guardianship is permanent parenthood in essence. It is appropriate where people cannot direct their own lives. It should not be used unless other less restricted means have failed, and it's not substituted for emergency adult protection. If somebody is in a dangerous situation and they need help, they are an adult and they're in the community, not in a facility, then you do want to call DSS if you need intervention. Don't forget, again, guardianship does not come in and make that emergency release. If you need help with somebody who's in a dangerous situation and they're an adult, call 911 or call DSS Adult Protection Services and ask for help. The first thing the DSS person is going to do is evaluate if the person meets the definition of vulnerable adult and if they need protection. If they are a vulnerable adult and they need protection, then DSS will likely step in. If they are not a vulnerable adult or they do not need protection, DSS will go away. They can be recalled again if circumstances changes, but again, it's not a substitute for guardianship, and guardianship is not a substitute for DSS emergency adult protection. All right, next slide. Limited guardianship, again, it's where you protect some of the rights. It could be the right to vote. It is going to, again, you have to make sure you understand what powers you have as the guardian and which powers you don't have, and don't infringe upon the right of the person. You may get guardianship to make medical decisions, but financial decisions are given to somebody else. And remember that if you get guardianship, even limited guardianship, there are some rights that are automatically gone. Next slide. Okay, we've talked about these, in particular, the representative payees, trust accounts, and other ones. So I'm going to skim over this because we only have about 15 minutes left. Next slide. Able accounts is another way to set up an account to save money for people. Does not require a trustee, and you have limited savings accounts and qualified disability expenses. That's another good thing to look about if you're talking about financial matters. Next slide. Next slide. We've already talked about all of this. And again, this is a rundown in the outline about the Adult Healthcare Consent Act. For those of you who want more information on this, the next few slides will show the list of priorities and how decisions are made. Next slide. I think we can skip through to next one. And this is information here on the Adult Student with Disabilities Educational Rights Consent Act. Next slide. And the next few slides will give you contact information for both Sarah and for people here at DRSC if you have further questions or need more information. And since we have 15 minutes left, I think, Aaron, do you want to come in and read the questions from our chat room and see if we can answer them?
Yes, absolutely. And thank you both to our presenters. Lots of information, of course. We will have this presentation up on YouTube, and it will be linked via our website and our Facebook page, in case you are like me and that was a lot of information to digest at once and you'd like to come back to it and watch it again. And Maggie has put the links that Sarah was discussing that were in the middle of the presentation, and links to our DRSC University schedule going forward in the chat. So those are clickable links right now. You can click, bookmark, whatever you need to do if you don't want to wait for us to get the presentation up on YouTube. So we have some questions coming in. Please put your questions in the chat. I will look for raising hands if that is how you prefer to do it. Our first question, do you have to be a South Carolina resident to be a guardian of an individual living in South Carolina?
The answer to that, I'll take that one, is no. It depends. Guardianship is where the person who needs the support is living. So the person needs to be here, but if their guardian can be out of state, and that happens very frequently.
And the same participant is asking for a general range of legal costs for pursuing guardianship. That might be a question to get in touch with you about, but I'm going to throw that out there as well.
Well, it depends upon, theoretically, the cost can, if the judge agrees, the cost can come from the resources of the individual. But I've been warning people about $4,000 to $6,000 is what to anticipate if the person who's bringing the guardianship needs an attorney and they can't do it themselves. Even if you decide you're going to do it pro se, meaning that you don't have an attorney and you're going to represent yourself in a guardianship matter, there's still going to be some charges, because the person who needs, who allegedly needs a guardian, that person has to have an attorney for them to represent them, and they have to have a guardian ad litem. And there's also some additional charges involving, like, maybe the medical examiner who makes the determination that the person's incapacitated. So those are some expenses that could be, $2,000, even if, you're proceeding pro se. So it is expensive. And that's why, when I meet with people, I'm talking to them, well, is there an alternative? Can you preserve this money and use some of these other alternatives that we discussed at length today?
One more question. Linda says, I was told that a supported decision-making document is not a legally recognized document in South Carolina, but has been used successfully by families. Can somebody speak to the legality of those kinds of documents?
A supported decision-making agreement is not illegal in South Carolina. It is not specifically mentioned in the law, and that's one thing that we hope to change, but it is also not prohibited. It is not, because people don't know about it. Also, it may be hard for them to understand what it is, but it is still something that you can use.
And I think you said this, but it's not illegal. I mean, it's a contract, basically. Yeah. And contracts are legal, and we sign them all the time, and they can have any kind, anything that's legal to agree to. And certainly there's nothing illegal about having somebody else help you make decisions. In the powers of attorney, the difference between that and the supported decision-making is essentially you're saying, I want this other person to take over for me and be, I think Anna Maria kind of described that as a surrogate decision maker for me, as opposed to supported. But the powers of attorney are recognized in South Carolina law, and the supported decision-making is not a far throw from that. And so but it's just not written out. Like the healthcare power of attorney is part of our statute. So it would be nice if there was a version that was part of the statute.
We do have about 10 minutes left for questions. If we could perhaps go to the next slide. So we have, perfect. So you got Sarah's, and now we'll hang with Anna Maria's contact information for a second. And I have a question from Regina. If helping an adult child with medical care, what's the standard documentation required to assist with billing and appointment scheduling? We see so many providers and are having trouble with procedures from one office to the next.
Well, a power of attorney is one way to kind of go around that, or to take care of that problem, because that's one of the things that can be anticipated, especially if it's the medical power of attorney. If you do it in advance, if the person has capacity at the time that the document is signed, and as long as that document is viable, if it's alive and not rescinded by the person, then you can show all of your medical offices and so forth that you have the power of attorney, and it specifically mentions medical care, and that should take care of that problem.
If the person is turning age 18 and they have a significant disability, and you do not believe that they're competent enough to signing the power of attorney, then I would recommend you call DRSC and maybe do some education with the providers on that Adult Healthcare Consent Act, which says that next of kin should step into the shoes in that circumstance. If two doctors have said the individual lacks capacity, then the providers should turn under the Adult Healthcare Consent Act to the next of kin.
Great. Okay, time for one or two more questions, if we have them.
Anna Maria had asked about co-respondents. I kind of threw that out there and had asked kind of what the reason for a co-respondent. Essentially, the court wants, how, you bring a lawsuit, there's usually a plaintiff and a defendant. And in this type of lawsuit where somebody's seeking to become a guardian, the person seeking guardianship is usually the plaintiff. We call that a petitioner in this kind of case. And then the person who allegedly needs a guardian, that person is the respondent. They're the ones who it's being brought about. Under the relatively new, it went into place in January 1 of 2019, our new guardianship statute identifies that there must also be a participant who's called a co-respondent. And the reason why that is we really feel like other people involved need to know about the case. So like, for example, if mom is incapacitated, mom's a widow, she has 3 kids, then one kid cannot bring a guardianship case and not tell the other children about it. And so the other children are named as co-respondents, so they know what's going on, and they have to be named under the statute.
Yeah, so I think, that's a really good point in that situation. Anytime that you're looking at supported decision-making of any form, then, who all does need to be involved. And I think Sarah's questions for all of her potential new clients will bring that out. But even before you go over to the law office, when you're really thinking about it, who is important to the person that you are seeking to protect? Who are they close to? Who do you want to be involved, or who do they want to be involved? It's very important in their future, and try to invite as many people as possible into the proceedings, at least the discussions early on, so that you can help hammer out some of the conflicts. You can avoid conflicts in the future. And you can also sometimes anticipate changes, or again, you can come into an agreement, who's going to be the backup for that guardian, or who's going to be, again, the next power of attorney. And the more people involved in the process, and at least the discussion, I think it does 2 things. It provides security for the person who is asking for the help. It also provides an opportunity for everybody to know what's going on and to come to an agreement and avoid future conflicts. And again, it provides that planning opportunity, which is so important. If you anticipate that a parent who's elderly is going to need to step out of the picture at some point in time, or facts and circumstances may cause them to be incapacitated at some point, but you've anticipated that and you have the backup up front, then that saves everybody heartache in the future. And usually what happens is we wait until an emergency occurs before we get help on making a decision, or we bring somebody in and ask them to make an emergency medical decision. And I'm already ill, I'm already in the hospital, and the person that you're speaking to and asking for a decision is already stressed out. It doesn't take away all the stress and all the worry in that emergency situation. But if you have a plan and everybody knows their role, that makes it easier for the family members and the people who are supporting that individual when they come to the hospital. And that's really, what everybody wants to have happen.
I've got 2 more questions, and that will be it for us. One, there's a reference made in the presentation to an entity formerly known as Circle of Support, and somebody is asking what that is now known as.
Well, I think nowadays a lot of times we just talk about surrogate decision makers or supported decision makers. So it's all the same thing. I know years ago when I first started working at Protection and Advocacy, it was called Circle of Support. So that's why I still bring that term up.
It's not an entity though. It's not an entity. It's just the people who you rely upon to help you.
Gotcha.
We all have friends and moms and all those people that we call on a regular basis to help us make decisions. But when you have a disability, somehow people think that's not okay. But we all do that.
And we have one final question. This might be something that we asked Linda to get in touch with us about, but let's throw it out there. If you don't have a person you feel 100% confident in handling the financial matters of a disabled person, what about the possibility of naming a family member and also appointing a professional paid co-trustee like a bank?
Yeah, both of those things you could maybe do a power of attorney, but have it limited. You could have co-agents so that they can keep an eye on each other, or certainly you can always name a trust company or a bank as your agent if need be. It's just, that's a little expensive, but so that is go talk to an attorney, because there's a lot of options there.
All right. I think that is it for us. We are going to get everybody out of here on time, which excites me a lot. Please do look for this on YouTube, on our Facebook lot, and please join us every month around the middle of the month for 9 more of these sessions on a lot of good topics. Thanks everyone for joining, and thank you to our presenters and to Callie for our interpreting, and to Phil for doing all the tech. Have a good rest of your day, guys.
Thank you, guys.
Thank you.
Bye.
Bye.